Hello, everyone. Welcome to the Marshall Cavendish talk on wills and LPs. Hi, I'm Lee Fung Peen. I'm a director at Yen Law, and thanks for joining us for this webinar on wills and LP. This is actually my launch of the book. My first one was the LP, and the second one is on wills, but I'm going to take it in reverse orders. I often tell my audiences, my clients, that actually doing your LP or wills is a great way to love your family, and it's a great motivation. And the reasons will become apparent is because if you don't do it, then things get really messy for your families. Now here we have a timeline, how it all fits in, whether it's your LPA, your lasting power of attorney, or whether it's your will, and the various stages of life and when you should be doing it. So from birth, 21 years, marriage or family, loss of mental capacity, and when you pass on. Right, so these are the milestones, and this is how it all fits in the time frame. So that's my book. The reason why I wrote my book is actually when Marshall Cavendish approached me and my editors approached me, they realized that a lot of communication going on out there by the government was very good, but it mostly focused on the how and the whats. So in this book, I wanted to explain to people the whys. Normally when we know the whys, that's when we are properly motivated and and that's when we actually get up to doing it. So what is a lasting power of attorney? In a nutshell, a lasting power of attorney is a legal document that allows you to appoint someone to make decisions for you when you lose mental capacity. Now, we are in a very fortunate situation in Singapore because our government in 2010 decided to roll out the LPA. Singapore was one of 5 English-speaking countries in the world to have the lasting power of attorney. The British in the UK have had it for 30 years, so the UK has it, followed by Australia, New Zealand, Hong Kong, and then Singapore. The only other country in the world that has the LPA or its equivalent are the Japanese. So it's very important that we do it as Singaporeans because our government has facilitated the process. Now, if you are in America or other jurisdictions, you don't have the ease of having one legal document to go to. Someone in America would have to actually instruct a lawyer to draft the thing from scratch. Now, of course, that's a lot more costly. And since I'm talking about countries and LPAs, in Australia, it's called the EPA, the Enduring Power of Attorney. And the nature of LPAs is that you have to do one in each country. Let's say the Singaporean has assets in Singapore, but he has assets in Australia and shares in Hong Kong, and he's thinking, hey, I must do my LPA. That's very good in Singapore because the bulk of his assets are in Singapore. But can his Singapore LPA be used in Hong Kong or Australia? No. LPAs are jurisdictional, so it's only recognized within the jurisdiction, right? So if you have an LPA in Singapore, you can't use it in the UK or the US. So you have to make arrangements in those countries if you have assets that you want your DONEE to manage if you lose mental capacity. Yeah, who's involved in an LPA? Well, the person making it will be called the donor, and the person having the powers is the DONEE. The lawyers are usually a certified issuer. Some doctors are certified, but not all. So these are the parties involved in an LPA. Very commonly, if you're married, like I am, then the DONEE would be your spouse. And what I plan to do is that, as in my mom's case, if you have adult children, you might want to appoint your adult children in addition to or instead of your spouse, because your spouse will be as old as you. Yes, so here we have personal welfare and one more. So the LPA in Singapore and around the world, those countries who have it, generally have 2 very broad powers that you're giving your DONEE. So in Singapore, personal welfare would mean that your DONEE would have the power when you lose mental capacity to talk to your doctors, to decide with your doctors what kind of treatment you have, where you stay, what kind of nursing home, that kind of thing. So that's one broad area. The other broad area is property and affairs. Now, equally important, meaning to say who would manage your HDB flat if there's upgrading you can't sign. So the whole idea here is that if you lose mental capacity, you will not be able to make decisions or even have the competency to sign all these documents, whether it's your insurance documents, collecting insurance payouts, or whatever it is, you will not have the capacity to do so. Now, just a sidebar, the other reason why I got very interested in the LPA is also that our National Neuro Institute has been doing studies, and they actually said that the incidence of dementia in Singapore is quite high, as with most countries, even Australia is reporting an increase in dementia in society. And our research in Singapore shows that the average onset of dementia in Singapore is actually about 65. That's the early onset of it, forgetfulness and things. And the more critical part is that the average age where dementia is advanced to the stage where you can't make your own decisions and you can't sign documents is actually 74. Now, if you think about it, the average lifespan of Singaporeans for, well, let's talk about men and women generically. Of course, it's longer for women. The life expectation on average is about now 85. It's actually pushing towards 90, 89 even. So let's say it's just 85. Let's take simple numbers. If a Singaporean resident gets dementia and can't decide anymore at 75, but he lives till 85. Now, I was thinking about it, wow, there'll be 10 whole years where this person will be alive and cannot make these decisions, whether regards to personal welfare or property affairs. That's quite tragic, and the family can't step in to help. A lot of people have concerns that if I appoint a DONEE and the DONEE goes so-called rogue, then I'm the mercy of this person. Well, that may be the case, and that was the case in a case called Yang Yin, right? But the DONEE obviously must do things in the best interest of the donor. So if you have a case, some of you may be already aware of this case, Yang Yin. He was a tour guide and he befriended and took advantage of an elderly old lady and got the LPA done. And he basically whisked away $2.1 million of her monies and sold off her antiques and such. But in the end, the long and short of it is that she had a niece that used to visit her regularly and found something was not quite right. Basically, she made a report to the government department in charge of LPAs called the OPG, the Office of the Public Guardian, and they did the investigations alongside the police. And this conman was eventually charged and convicted and jailed. They managed to recover some of her monies, but not all of it. So I tell this story because it is actually, in Singapore, we are fortunate that we have authorities that act very promptly, and if told, they will investigate promptly and prosecute promptly. So even an old lady like that, as long as you have some extended family or friends that will make a report, these con artists and scammers can be stymied. But of course, while you're still alive and you still have mental capacity, there are procedural steps to change your DONEE if you want to change your DONEE. Now, of course, in that timeline I was talking about, let's say someone loses their mental capacity at 75, but they live to 85 and they don't have an LPA, what you do? And that's what I do in practice a lot. I help families where their family member has fallen into a coma or has dementia and they haven't done their LPA. So I am appointed to help them make an application to the family court to appoint a deputy. So it's called an application for deputyship. It's in place of where you don't have an LPA. If you haven't signed an LPA, then you have to apply to court to be appointed. Now, the deputyship application can be quite tricky because sometimes it get contentious. This year alone, I've done 2 contentious deputyship applications because one was about 2 brothers that wanted to be deputies, but one of them owed debts to the mother who had dementia. And the brother I was acting for rightly said, and that, look, you owe mom money. I don't think you should be the deputy. Of course, I advised him to say that, well, if he promises to pay or there's some way to avoid the conflict of interest, he can be. So that's just a short summary of what can happen if you don't have an LP. It's just like a will. If you don't have an LP like a will, then things can get complicated and messy because there's no clear instructions from yourself to your family who should be so-called in charge, who is making decisions. Now, some people are also concerned that, oh, I don't want to do the LP because the DONEE has all kinds of rights. They can do anything. They can rewrite my will. They can marry me off and that sort of thing. No, these are the list of things that cannot be done by a DONEE. Right? There are certain limitations. Basically, as you can see from this list, it's like basic human rights. You can't change these things. It's more for, as we saw in the previous slide, for personal welfare and for management of assets. And of course, if a DONEE actually does not do a good job and family member does complain to the Office of the Public Guardian, then the Office of the Public Guardian can investigate. But even if no one complains, a DONEE is expected to make an annual report to the OPG so that the OPG will review and look at a record of all the decisions taken and the money spent. So there is a system of accountability for DONEEs. an annual report is required. Right, the next segment is actually about wills. But before we go into the wills, I think there's a poll that we can do. So everything in Singapore is efficient. My family will automatically gain access to my assets should I pass on. Well, half of you said true and half of you said false. Well, half of you who said false is correct. Your family will not automatically gain access to your assets should they pass on, with a few exceptions. Only properties held as joint tenants will pass. What will not pass are things like automatically joint bank account, they will not pass. Your shares will not pass automatically. Automatically as in, there are two parts to this, rather to understand what you mean by automatically gain access. You can gain access if you're a joint bank account holder, that's for sure. But of course, if the bank finds out that your joint bank account, one account holder has passed on, then as I say in my book, it will be frozen. Like you're gonna have access to it anymore. If you have a property and it's joint tenants, then you become the sole owner under the law. But of course, you still have to take steps with a conveyancing lawyer like myself to process it so that only one name is there. Same for the shares. So you may be a beneficial owner, you may be entitled to it, but you don't have automatic access in that sense. It's not yours automatically in a legal sense. You have to go through the procedures. And that's what I deal with in my book. Number two, I've already done my LPA. My DONEE can help me to manage my assets if I pass on. Okay, 2/3 say true, 1/3 says false. My DONEE can help me manage my assets if I pass on. No. So here again, 1/3 of you are correct. 1/3 of you are correct. The LPA only talks about when you're alive, but you lose mental capacity. The minute you pass on, the LPA does not work. And if you have a will, then yes, it's a great way to love your family because then a will specify everything. Question 3, a will is the document that can determine how much you transfer your assets, correct? Who inherits what and when they should receive it, correct? Who manages your estate as an executor, correct? So correct, 2/3 of you are correct, it's all of the above. That is the reason why a will is important, because it deals with all the above. So how does it all fit in? So the earliest time you can do a will is when, I'm sure you can guess, is when you're 21 years of age. When you reach the age of majority, you can do your will. And you can do your will as long as you're alive and you have mental capacity. And so they say a will is, in law school, I learned under the law of succession, a will is described as ambulatory. That means that you can change your will at any time. Just like Mr. Lee Kuan Yew, he changed his will 6 times before he got his 7th one. So you can change your will anytime before you pass or before you lose your mental capacity. So that's why I have these milestones here. Now, in terms of time frames as well, most people don't think to do their wills at 21. That's understandable. In fact, I have one section in my book, our interest, I actually wrote on the aspect of our army boys who go to war and things like that. So there's a whole class of wills called privilege wills, but most people generally don't do their wills until perhaps they get married. But actually, this week alone, came across a very sad cases where you have people in their early 30s passing on from tragic accidents, and they have bank accounts, they have small investments, and even sometimes even large investments, and they don't have a will. And that makes it very cumbersome for the family. So I would say that the best time to do a will is when you start working, and then you want to do a will to make sure that you do, as I said in the last poll, all of the above. Choose the executor, choose your beneficiaries. The next stage in life where it's good time to redo your will if you already have done one, or the time to do your will is when you get married. Why? Because some of you may already know that marriage revokes your will. If you have done one and then you get married, it revokes it. So you need to do a fresh one. Same goes for your CPF nomination. A lot of us, when we start working, we get CPF, and some of us do nominations to our parents a lot of the time. But when we get married, we forget, and then we don't do new nominations, but the marriage will revoke the old nomination to your parents, and then it goes under intestate, which of course will be done by the CPF board. Just to be clear, CPF funds is not dealt with under your will, under the laws of intestate. CPF board has its own regime for CPF funds that's dealt with in my book as well. So if there's a nomination, of course the CPF will attend to it. If not, then the public trustee will get in to distribute. Of course, this is a very long process. You can read about it in my book. So the second time you should seriously consider doing your will, or you should be advising people to do your will, is when they get married. Of course, the other instance where you should be thinking about doing your will is when you're married with kids. And usually these are the 3 milestones in life where you should be doing about doing your will or updating your will. Of course, the last one I would say is that when your kids are adults, when your children are adults or your beneficiary as adults, then you should seriously consider updating your will. Right? So these are the time frames in which you should be doing a will. Now, I spent some time on this because a lot of people think, oh, I do one will and I'll never do another will again because I want to save money or I don't want to bother. So I say that updating your will is like your iPhone OS. Right? If you don't update your OS, your phone is not going to work. The battery life is going to not be good and you will not get the latest apps. So updating your will is something like updating your iOS. Of course, not that frequent, but you need to do it. Yeah, so that's in terms of timelines. And unfortunately, I've seen wills that are 25 years old and the postal code in the will is 4 digits. And many things in the will are outdated. People have passed on. Assets are not even around anymore. And that makes very difficult for the executor to carry out his duties. Some of the reasons why I've heard people don't want to do their wills. One of the top reasons is in Singapore, for the older generation, is reason number one. But now I think it's not so much about being pantang or superstitious. A lot of people say, I don't have the time, which is actually very tragic. And only rich people need wills. In fact, the contrary is true. The high net worth people that I've dealt with actually are very interesting. They actually teach their children to do the wills as early as possible because they know that doing a will actually saves money and saves bother. So all these are economical things to do your will. And actually wills in Singapore are comparatively cheap compared to the US, UK, Australia, and other first world countries. To say that my family will divide things when I'm gone, well, I will deal with it at the last part of my webinar because actually there's a lot of procedure that needs to be done, legally speaking, in the courts before your family can do that. And if you don't have a will, that process is a lot more tedious and more costly. And the sixth one, I'll just do it before I die. I had a case where a lady had written her will on a paper napkin in a local hospital. And the family came to me asking me the advice. So I had to research, I had to look very closely and give my opinion on whether the will was valid. In that particular case, after a week of research, I wrote my opinion and I was of the view that that will not be regarded as a valid will in a Singapore court. Yeah, but it's also not a good idea because the other stories I will tell you is very true. I get inquiries on a monthly basis to attend at hospitals, and now it's virtually impossible to go to a hospital, and so it is not a wise thing to do to wait to the last. So what is a will? In a nutshell, it's a distribution of assets. It's the appointment of the executor. Like that is what a will does. It is very simplest. You're appointing an executor. You have a distribution plan of what you want to do with your assets. That's what a will is. But you see in the center of my slide, there's such a thing called a grant of probate and letters of administration. Now, what is that? Of course, the third point on this slide is that the executor distributes assets according to the will. A lot of people may not realize that if you don't have a will, your wishes will not be fulfilled. Yeah, I just want to remind everyone that it's a great way to love your family with the last thing they read from you. Actually, I came up with this saying because my own father passed away when I was 22, and I was just 1 year after I finished my army training in Singapore. My father had cancer for the duration of my 2.5 years in the army, and not a wealthy man, but a very considerate, loving man, and a humble civil servant. And he intentionally did a will. And the minute I was 22, he made me an executor also because he didn't say, I don't want your mother to be worrying about paperwork. And he wanted me as a young person to carry out those duties for him. And of course, the will made it easier for us to grieve because there were clear instructions about what to do as well. And everything was clear. And he also taught me that what he did for me in listing the assets alongside his will made the job so much easier for me. A lot of the things that doing a will, there are a lot of side benefits. One of the side benefits is that it forces you to get organized about your assets. Now, one of the most tragic things that I come across in helping people with their wills and helping the executors or the family members apply for the grant of probate or the grant of letters of administration is that the poor wife or the poor sibling comes to me or the spouse comes to me and says, I've got the will or I don't have a will. And the other problem is that I don't know what assets the person had. Now, 30 years ago when my dad passed away, everything came in the post. Your CPF statement, your bank statements, everything came in hard copy. Nowadays, I think you all would know that everything is now soft copy. Now, if a husband has investments, credit cards, all kind of statements, bank financial statements, and they all go into his inbox, and his wife doesn't have his user ID and password, she's going to have a heck of a time trying to find out what his assets are even before she can apply to court or even before she can go around administering it. Yeah, so that's a practical point, and I deal with it in my book as well. Now, what can a will do for me? The executor is the one that you want to choose as someone is trusted and reliable to do the paperwork with the lawyers and go to the banks and go to HDB to sort everything out. So someone trusted, someone reliable, someone good with paperwork, someone who has the time and will commit to it. Bear in mind, executor can renounce. I've had a case where a will was done 20 years ago. The person that made the will, she did not tell her sister that she was the executor. 20 years later, when she passes on, the sister says, I'm in Penang, I'm not going to do this. I'm already 68, I'm not going to come down to Singapore. So that's another reason to update your will, right? Because your executor is going to need to do all the proper paperwork for you. Now, I put financial savvy at point 3. That only really comes in if you want to give powers of investment, or if your executor is also going to act as a trustee for you. Like for example, if you have young children and want to give your wealth to your children, but they are too young and you want someone to manage for them. Some people feel that their spouses are not financially savvy and they want to have other people do it. Yeah, so these are the considerations. Now, it's also very important that, remember I mentioned in your timeline when you are married and when you have a family. Now, that's where you should also do a will, because I'm married with kids, and I think it's very important that you should have a will, because the will is the cheapest way for you to appoint a guardian. If in case your children are below 21, they need a guardian. And in Singapore, everything is very officious and formal. If you don't have legally appointed guardians, grandma and a neighbor cannot sign consent forms in schools. I cannot do many things in schools, right? So I've had a case where I was helping this family where mother and father have passed on, one from a car crash, and 2 years later, the mother died from cancer. So 3 boys, and the boys' uncles had to apply to court. They had to go through the whole process. They had to get the consent of other uncles and aunties as well for the sake of completeness. And the hearing itself was very short because the High Court judge I attended to was very empathetic, but he just commented to me that all this would not have been necessary if they had done a will. So they had spent close to $8,000 to $10,000 for the court application, but a will definitely will not cost you $8,000 to $10,000, especially a clause for guardianship. Another area is, and it's very challenging for parents with special needs children. It's very important because these parents want to plan beyond their own lifetime. Some special needs children really need a lot of care, and they want to plan for them. So you will be considering doing a trust, working with SNTC, having proper provisions for the special needs children. Because you can't just give someone with special needs a HDB flat, because I've come across many cases where they just are simply afraid that they will be conned into selling it, or they wouldn't know how to manage it. They wouldn't have the mental capacity to even manage it. Planning for children with special needs or loved ones with special needs is very important. Now, if you're a business owner, it's also very important that you have wills, because very tragic things can happen when business owners pass on. Most business owners ideally want to have their business income continue to bless their families even after they're gone. But that needs a little bit of business succession planning. If you own shares, an increasing number of my clients who are shareholders in, let's say, private limited companies that are doing reasonably well, they have dividends and the shares may be worth something of potential investors. Now, if something happens to them and they don't have a will or they don't have shareholders agreements, then things can get very messy, because some people don't want their families to be shareholders because they get voting rights that they don't want them to have, and to mess up the company business, or create stalemates. So they want the families to benefit from the profits of the company, but not be involved in management. So they want to keep it clear. Sole proprietors also, if you're a sole proprietor without a private limited company, now that also presents its own set of challenges, because if you're a sole proprietor, everything is in your sole name. If the sole proprietor passes on, then everything ceases, whether it's a tenancy, whether it's bank accounts, everything is frozen. So there are certain cons to having a sole proprietorship in terms of business succession planning. So there are other considerations there. I do divorce and matrimonial work, and one of the first things I tell my divorce clients is that after I help them strategize for their divorce or help them prepare for their divorce, I also say, please, if you don't want your soon-to-be ex-spouse having 50% or 100% of your estate, your assets, please do your will. In fact, in one tragic case, the gentleman in the divorce had a heart attack and he died, and his parents were very, very unhappy because the soon-to-be ex-daughter-in-law got half of his assets, and the parents, because they didn't have children, the parents will only get 25 and 25%, and they were very unhappy, but I told them that's the law, you can't sue to recover. That's one case where you would want to exclude beneficiaries in your will. Of course, there are other reasons to exclude, and that's why you should consider if you wanted to do that. And conversely, you want to do a will because you want to include parents, charities, and even stepchildren, because all these people fall outside the Intestate Succession Act. So a lot of Singaporeans think, oh, there's a law that splits things up, so I'll just go with that. But unfortunately, that doesn't cover parents. So the minute you have children, your parents are no longer entitled to anything if you don't have a will. The law in Malaysia is different from us. Parents still do get something, it's in my book, but in Singapore, parents do not get anything. So if you want your parents to have something, you have to do a will. Of course, charities that you support will not have any share as a beneficiary unless you specify. Now, stepchildren also do not get unless they've been legally adopted. But some people do not legally adopt their stepchildren. So if you do not include them in your will, your married spouse gets a share, your biological child gets a share, but your stepchildren get no share unless they are legally adopted. But even that is under the Intestate Succession Act. But of course, I have clients that have remarried and their percentages are not equal. So you might want to consider this as well if you find yourself in that position. This is my recommendation, and it's a common one for married couples to do what we call mirror wills. So mirror wills is when Alan, the husband, says, if I die, then everything 100% to Betty. But if Alan and Betty both die, then Alan says, then the children and my parents get, for example. So the first part of the will say everything is to the spouse. The second part of the will, when both Alan and Betty, both spouses are not around, then there's a different type of distribution. The same will go for Betty's will, everything to Alan. But if Alan dies before her or she dies together with Alan, then it's the same distribution. So that's why it's called mirror. So this is one of the very popular and common wills that we have in Singapore. So what happens actually after a person dies, whether they have a will or they don't have a will? If you have a will, can I go to the bank to close a bank account? If I have a will, can I just start transferring things? The short answer is no, because you haven't been legally appointed by the court yet. So bear in mind what I said in the beginning. A will is where you have a distribution plan, you have a list of beneficiaries, and you appoint someone to take charge of to distribute it. But the person is not legally authorized to do so yet. So that's where my next slide comes in. So this slide you see at the bottom right, next to the box called will, we have the box called probate. So that's what I will talk about. Some of you may be already aware of it, but this is the legal process that I'll quickly go through with you. Probate. A grant of probate is a legal application to court to get a judgment from the court. It's a court order. So whether it's a grant of probate or a grant of letters of administration, both are a court order to authorize, in the case where there's a will. In the grant of probate, it is a court order that appoints the executor named in the will to be legally authorized to manage the bank accounts and properties and whatnot. Because as I explained in my book, banks and government bodies are not interested in looking at the will, because a will is just a distribution plan. They are interested in whether the person in front of them is officially authorized under the law to do transfers and to sell. Whether there is a will or without a will, the person who is in charge of distribution, the executor or administrator, has to be authorized by the court. So in the grant of letters administration versus a grant of probate, the process and the fees are very different. Right? And the grant of letters administration can get complicated because in the will, if it's validly done, the executor just applies to court. Once the court in the grant of probate assesses that the will is authentic and not been tampered with, the court will just approve it and leave the rest for the executor to do and doesn't ask too many questions. But in the grant of letters administration, the judge, before giving the court order, because there is no will, has to ask a whole series of questions. And I've known grant of letters administrations to actually last more than 12 months because some family situations are very difficult. There's a priority of application. I had a case where a spinster, she was in the 70s and she died and she was worth a few $1,000,000. She did not leave a will. So in that case where a person dies unmarried, the persons that are legally have the priority to apply are the parents. But her parents died in China in the 40s. But the court wants to know, okay, before you say that the parents cannot apply, I want you to prove that the parents cannot apply. In this case, if there's a death, then the court wants a death cert. And then that's where the family's inconvenience and trouble came about, because they couldn't even find proof of that. So it took a very long time for them to persuade the court that their parents were dead. And then the next persons with priorities is her siblings. So she had 9 siblings, 3 of them who died during World War II. And they were estranged from those families. So to get the death certificates again from the deceased siblings was also quite a challenge. You can see the difficulties and inconveniences of not having a will. So that's my book, A Guide to Setting Up a Will and Managing a Loved One's Estate. Well, thanks for joining us. We're just going to wrap up. If you have any other questions, you can drop me an email and I'll be happy to follow up and help you in any way that I can. One thing in closing, I can just say is that the percentage of Singaporeans doing wills and LPA is exceedingly low. Thankfully, our vaccination rates are not that low. In fact, quite good. The LPA, I think last year, July, the government reported 1.2%, which is very, very low. And for wills, Temasek Poly students did a survey some 6 years ago or more, and only anecdotally, they polled, I think, about 1,000 people, a small survey, and only 10 to 15% had done their wills. So LPA at 1.2% is very low, and wills at 10%, 15% is very low as well. Now, the reason why I believe the government is encouraging Singaporeans to do their wills and LPA is a very simple thing. Our government is very, very practical. Now, imagine if 99%, 98% of people don't have an LPA and don't have the will and all are rushing to court to do it. The government has spent a lot more money on building court infrastructure and employing court staff and judges just to process these sort of things, which actually can be much more simplified if Singaporeans and Singapore residents had wills and LPAs. Yeah. All right, so that's the practical point of it too. All right, thank you so much for your time. I hope this has been good for you. Thank you so much.